All right. Good morning. It is February 14th at Senate Judiciary. For those wondering what happened to S13, we rearranged some scheduling after conferring with the House and regarding another bill in which S13 might be put into. So in the future, that policy might rear its head again, and we'll discuss it. But we're starting early for S12, and we have Ledge Council here to walk through some changes. I think we see the light at the end of the tunnel for this bill. And yeah, please take it away.
Good morning. For the record, Michelle Childs, Office of Legislative Counsel. And you should have draft 2.2 of the committee amendment. So you already had seen one amendment last time we met on this bill. The things that I had highlighted in yellow in the last version and you were in agreement with, I just took out the highlighting and cleaned it up. So it's all just incorporated here and it's no longer highlighted. So the things that are different and this one are highlighted in yellow. So I'll just draw your attention to page 5. And this was in the last draft, but it was kind of a suggestion from me. And I didn't want perhaps people who are tracking the bill, stakeholders who are interested in the bill, to kind of lose track of this change I made. And this has to do with the any misdemeanor that would be excluded from being a qualifying crime. And so you see on page 5 on lines 12 and 15, I added any offense that would require registration with the sex offender registry. And the next change is on page 30 in section 7609. And this is the section that actually made me think about the registrable offenses because under current law, with regard to expungement of criminal history records for 18 to 21-year-olds. There's a provision in there that talks about keeping an index for any type of registrable sex offense that is expunged under current law. And I think I talked to you a little bit about my question on whether or not there were any offenses that would fall under that. And so, we put up front under qualifying offenses, just explaining that as the registrable sex offense is not a qualifying crime and not eligible for sealing in the proposal.
And that would also apply to the 18 to 21-year-olds.
Correct.
Okay.
Yeah, for everybody. And so if you look at the language, and so a lot of this, there's a lot that's struck out. I just reorganized it some because I felt like it was a little confusing to me the way that it's structured now, where it says that basically the court expunges after 30 days upon completion of sentence, but then subsection C says still that the person is to petition. And so I just restructured it, I think, to be a little more direct. So you look at the language at the bottom of page 30. So not withstanding any other provision. So just clarifying that, this is an exception to the general sealing rules that you have in 7602. A person who was 18 to 21 years old at the time they committed the qualifying crime can petition with the court to seal the criminal history record relating to that qualifying crime after 30 days. So this is providing, essentially, this is like an expedited process. So they don't have to wait those time periods that you have elsewhere. So whether it's the 2 or the 5 or 3 or the 5 or the 7 or the 10 or whatever you guys gonna settle on. And the conditions that the court would grant the petition are simply that they've paid any restitution. So that's like what you had. These are the ones that are upfront in the other provisions. So paid any restitution, and the respondent, meaning the state, has failed to show that sealing the record would be contrary to the interests of justice. Now, those are, these are all policy decisions for you. I just was using what you have as the standard for the other ones. But that's your choice. Then subdivision 2 on page 31 is just that the order, the notice, and the effective sealing is the same as what you have for sealing in general, meaning that the person can say that they don't have a criminal record. The process of sealing all the records for the different agencies that might have the records would be the same. So it's fitting into the existing system. I kept the exception there on B, with regard to current law, that if there's a criminal history record that includes a qualifying crime and a crime that is not a qualifying crime, that they don't seal the record. And then on page 32 is the issue of access. So, and this is what you're dealing with in a larger picture around, so what do you want the access to be? So in this circumstance, under current law, it's expungement. So nobody has access. The records are destroyed. So I just kind of put in a placeholder here. So when you decide on the policy around what you want to do around law enforcement access in general, do you want, for the 18 to 20-year-olds that have the sealed record, do you want those same exceptions that are in 7602 to apply here? Do you want special ones for these? So maybe you have a more limited access. But again, just policy thinking for you about what you want the access to be. So it could be the same as whatever you decide with regard to the other records, or you could do something that's very specific to the box. And that's it. I did just note at the end of the bill, I just put a little placeholder on page 39. Is if you decide to stick with what's in the draft now, which is to move from expunging records related to a deferred sentence. That's current. Expungement is current, but if you switch that to sealing, which is what you still have in the draft, then we'll want to add some language in there clarifying that we're only talking about that would be prospective. Yeah. So anybody who's already been sentenced prior to the enactment of the bill, it would not affect them. And then I also just put a note on the effective date, depending on which direction you go on the law enforcement access. If you did decide one of the things, there's the judicial review option, but then there's also the discussion around whether or not there would be a model policy that would be followed. And if you did something where there would require that law enforcement only accesses the records pursuant to a model policy, you want to be thinking about the effective dates in the sense that if you didn't accommodate for the model policy, you have law enforcement access that would kind of open prior to the adoption of the model policy. So I just kind of, for me, it helps me keep track to not forget that we would need to tweak that depending on what direction we go.
I believe regarding the section 5, the deferred sentences, I believe the consensus of the committee is that we're not going to touch or change deferred sentences.
Okay, so you want to keep that with it being expunged?
Mm-hmm. Yeah.
Okay, all right. Sorry, I didn't realize that was a decision that you guys had already made.
So I think the remaining decision points involve timelines. And we'll be hearing from the crime research group next week regarding persistence and recidivism rates, which I think will, that data will inform as to whether or not we want to stick with either the 3 to 7 years or increase it. So I think that topic is just going to be in limbo until we hear from them, I believe on Tuesday or Wednesday next week.
And I can do an updated draft with the deferred language and send it to Kayla if she wants to send it to the witness from CSG. I don't know, because so that they can see what you've got in the bill now, if that's helpful, or
yeah, that can't hurt. Right. And then I think the next piece, committee, correct me if I'm wrong, but it seems like the committee is leaning more towards the judicial review process for accessing sealed records. That's what it sounds like. We are going to be hearing from Judge Zone shortly, 15 or 20 minutes. There are two paths possible for that. There's the model policy, in which we would want to put in our own ideas as to what would be in that policy that would be and that would be developed by the Criminal Justice Training Council, and also what type of teeth we can add to it as to or regarding, you know, somebody accesses sealed records for a illegitimate purpose. Do they lose their license to be a police officer? Do they, you know, what type of consequences are there? With the second and the other track being judicial review, in which the officer contacts the state's attorney to file a motion to be reviewed by a judge to grant access to those sealed records. Personally, I think it should be the same for anything that gets sealed. I don't know that we necessarily want to create two separate tracks for people who are 18 to 21 compared to everybody else. That's just my opinion. Yeah, so those are some initial thoughts. Am I missing anything, or is there anything else? Any thoughts, comments, or questions in general regarding this bill right now?
I guess I'm interested to see what Judge Zolli has to say about access to the records. And looking at information received last year while in here, it appears as though over half of the states in the United States allow access to these records, to include the Oregons, the Washingtons, the New Yorks, Delaware's, Colorado's. Generally, they don't move, but they still all access records to it. My concern would be such as we have discussed already, would be if we're looking at judicial review as to, first of all, I think law enforcement have access, that everybody knows that anyways, okay, so, but how cumbersome is it going to be for the judicial review to take place on a day-to-day or weekly basis? And my question to the judge, something can shed some light on for us.
Yeah. Senator Rose.
I guess I sort of was under the impression that it would be a pretty rare case in which someone would be asking for access to a sealed record. So I wouldn't imagine it would be happening every day or even weekly.
For road troopers or road officers, yeah, once in a blue moon. You know, for detectives, if you want to add maybe once a month, maybe. Well, actually, I shouldn't speculate. I think that's something we want to hear from BCI on the Department of Public Safety. But I would suspect that detectives who are doing the more complex cases probably would access it a little bit more frequently than the road officer. So, yeah.
And I don't oppose the judicial review portion. All I'm saying is that the backlog that we presently have, as far as the SA's offices having access to judges, I mean, that's my concern.
Yeah, no, I hear you. And I definitely want to hear from Judge Zone about that. My understanding is, you know, in sealing the record, we're trying to keep it relatively tight. So it wouldn't be a regular thing that people were asking for.
I'm just hoping he says that, yeah, we can make this work.
Yeah. And I think the other question would be, what questions does the judge have to answer when they get a motion to review or to open access or to grant access to a sealed record? You know, does the judge have to be the one who just says, yes, this is a legitimate criminal justice purpose? Or are there other elements that they have to say are relevant for accessing it? I think those will be some questions we'll have to answer, which, yeah, Judge Zone will be able to shed some more light on it.
And my first response to that would be, first, foremost, it's officer safety. if they're executing a high profile warrant or something, and they need access to this, other than that, it's something that I want to ask officer safety first and foremost, and the public safety to follow them by that.
Any other thoughts?
I have a question, which is, have you guys identified, I know there's been discussion around like what would be the circumstances under which someone could file a motion for access? Have you guys, has anybody, either witnesses or anybody like provided you with suggestions for those limits for like those limited reasons or?
No, my hope was that Judge Zone would provide some perspective on that, but I think it will also more so be from the Department of Public Safety, mainly the BCI division, that would shed some light on that.
Maybe Judge Sony has criteria that other states use as far as access to exam records.
Yeah. It's like pretty close. I think we can hit pause for now and then come back at 10 when Judge Zone. Is Judge Zone coming in person or?
I believe in person.
Okay, great.
Judge Donay also planning to talk about the petitionless process, because I do still have a concern with the things that are no longer crimes.
I thought for the things that are no longer crimes, it's we're allowing for them to be expunged.
Yes, but I think it should be petitionless. I don't think the lay public should have to know and be paying attention to everything we do in this building to ask for it. If it's no longer a crime, it should just be taken off the record.
I'm remembering, I think the question was if the petitioner, not the question, but the issue is that the petitionless isn't really petitionless, is, you know, if something's no longer a crime, somebody is going to have to figure it out and look through the database to figure out what cases need to be expunged.
Yes, and the place that I stand in is that shouldn't be a lay public person that has to know that. It should be an attorney or a judge or someone who actually has the legal knowledge.
And we don't do that now.
We did it for cannabis.
Yeah.
So can I just ask something? So did I hear you say that you wanted to have the records related to something that's not a crime expunged and not sealed?
Yes, I believe that's how it currently is, right?
That is current.
Yes, but that's not how it's been in these drafts.
Right, yes, I think that we do want to change that.
You want to change that.
Or
So
the
that would be, so those offenses would be expunged and
Yeah.
not sealed. Okay, that's, all right, that'll work.
Well, we're gonna attempt to have someone identify what those offenses may be with those campus.
I mean, it's all speculative as to what may not be a crime in the future, so.
What about
I-
misdemeanor versus felony at the time?
Pardon?
What about misdemeanor offenses at the time versus felony?
Well, they'd still be offenses, so they wouldn't fall under that category, in my opinion.
I think it's gonna be a finite. Charges in house. Right, numbers for the west side.
Switch rates.
4 o'clock.
Possession of a
Yeah.
sword.
Utility night.
Sorry. All right, yeah, so I think we can take a